And welcome back, everybody, to the Law and Crime Network. I'm your host this afternoon, Rachel Stockman, also editor-in-chief of lawandcrime.com. Thanks so much for joining us this afternoon. As we wait, it is the lunch break in the so-called, what we're calling it anyway, the Cloud 9 murder trial. It's a trial that we are following gavel to gavel out of Florida. And I want to bring in a defense attorney who practices in Florida, Mark Eiglarsh. He has been following this trial. Mark, are you there with me?
I am. How are you, Rachel?
Good to see you. And look, your tie matches the background of your wall. That is very impressive.
I'm a fan of the royal purple, yes.
I love it. Okay, so let's talk a little bit about this case. Specifically, we're going to get into some of the details, but I want to talk to you about something that confused us here at Law and Crime and confused a lot of our viewers, and that was the fact that there's actually two jurors listening to this trial, two sets of jurors. Why is that the case?
Okay, so you got to follow me here. There's no simple, quick answer. The quick answer is because one of the defendants filed a demand for speedy trial, and that warranted two separate juries. Now, that doesn't answer the question. I can take you through it step by step, and you'll go, now I get it. Do you want a little longer of an answer?
Okay, we got a little more time, so give it to me.
Okay, so let's start with a general rule in Florida. I feel like I'm teaching my law class. Okay, that when all three defendants are charged in an indictment or information, they're going to be tried together. That's the general rule, unless one of the attorneys chooses to send one of the defendants out. In this case, no one did that. So far you're with me. They should be tried together, right?
Yep.
Right?
I got it. I got you, Mark.
Okay. What changed was that King, one of the attorney's lawyers, King's lawyer, said, wait a second, if I filed a speedy demand, a demand for a speedy trial today, that means they got to bring me to trial within 60 days, and that'll push it before the November 27th trial date. Let's do that. That'll screw with the prosecutors. Maybe they'll offer us some deal. Maybe they won't be able to get their witnesses in. They're planning for November 27th, but if we demand a speedy trial, that'll speed up the process as it relates to that particular defendant, King. So let's go for it. And he did that. He filed a speedy demand. That means now that prosecutors have to bring him to trial within 60 days, plus a 15-day recapture period. They didn't bring him to trial within 60 days, so King's lawyer filed a Notice of Expiration of Speedy Trial Time, NOE we call it. That means a hearing within 5 days is conducted, 10 days from the date of that 5-day hearing, and they did. They set it for November 13th. That's when a jury had to be sworn, because if they didn't swear in a jury, he would have been forever discharged from the case. He couldn't have then been joined with the others on November 27th. The prosecutors would have lost the case. So what the judge did is he swore in the jurors on November 13th. He's bringing those jurors back on November 28th, the day after they're supposed to pick a jury for the other two. And then they'll reconvene, and those separate jurors will hear a lot of the same evidence together, but they will then be deciding the fate of King separately from the other two.
Okay, so that helps a lot because it's a bit confusing and a bit technical, having to do with specific Florida laws and the right for a defendant to have a speedy trial. But let's talk big picture here. How does that affect the actual trial and what happens in court? I mean, having the two different sets of jurors there, does it change your defense strategy? Does it change how things unravel in court?
I think it can, to some extent. Let's start with it generally doesn't, because they're hearing the same evidence and you're just questioning, the jurors, the potential witnesses, excuse me, and each jury, is hearing what's going on in court at the same time, same everything. If, however, there's a way to, and I don't know that they're going to pull the other jurors out so King can do their thing alone. I don't know how the judge is going to conduct it, but assuming that both juries are there, it really doesn't change much. It doesn't, because they're just cross-examining the same witnesses, and if King's lawyer is going to blame the other two, then the other jury is going to hear that, or King's lawyer is going to say, my client didn't do it, I don't know who did. Same type of scenario. So no, the only difference is that a separate jury decides King's fate, and then a separate jury decides the other two co-defendants.
Okay, so let's tackle this like you're a defense attorney, because you are. Yeah. What do you see as the biggest weakness in this case?
Let's assume for a second, because we haven't seen the state's case, that their case is made up of eyewitness testimony. Okay? Now, some people say, well, that's all they have is eyewitness testimony. That's what most prosecutors have. When I prosecuted armed robbery cases, most defendants, surprise, surprise, don't wait till there's, a busload of nuns around, DNA evidence, fingerprint evidence. Most of the time, that's all you've got, like a one-on-one, right?
Yep.
And so, defendants shouldn't be able to get off solely because they wait to isolate a single person. They should be convicted if the evidence is compelling enough. So we don't know. Let's assume that there's no DNA evidence, no fingerprint evidence, and as a defense lawyer, the biggest weakness is, wait a second, you're claiming that my client shot the gun. To do that, wouldn't there be DNA evidence on it? Not necessarily, by the way. There rarely is, only on episodes of CSI. Wouldn't there be fingerprint evidence? Not necessarily. A gun is not the best surface to get, but these are the things we argue. Wouldn't it be on the casings, right? You have to put the bullets inside the weapon. Surely there must be some DNA or fingerprint evidence. The absence of that type of evidence will truly hurt the prosecution here.
Well, one of the things, so we had a firearms expert on the stand this morning, and one of the things the defense was able to get at was, well, the firearms expert established that there were likely 3 weapons that were firing because of the different bullet holes that were found near the scene. However, the defense was able to get the expert to admit that she wasn't clear exactly when those bullet holes were made. In other words, they could have been, Cloud 9, which is a club there, is known to have some fights and altercations. Potentially, they could have been made then a different time than the night of this incident.
True, a good point to be made. I think this case hinges upon, how do you prove ID? No one's saying, so the elements have to be proven by the prosecution. That's going to be easy, okay? Somebody died, they were shot, easy second-degree murder, and all the other charges. So this is just an ID case. It's a whodunit. And then the issue becomes, how compelling is the eyewitness testimony? You'll have someone sit in that chair and say, that person right there, let's use King, for example, that guy right there, to the exclusion of anybody else, I saw him do the following. And I was certain of it that night, and the defense will try to say, well, there was pandemonium, and people running around. Yes, but I saw that guy say and do the following. And then jurors will either believe that witness or not.
And there's one incident where we know we're likely to hear from an eyewitness that describes very clearly, I have money for bond, and the guy basically says, Barrow basically says, I'm going to shoot this place up. And he's very specific with the wordings that he used. Does that help?
I think it does. It makes it less likely that a witness would manufacture that type of statement. When I read it right away, I believed, for what it's worth, that statement was made. Now,
and I just want to be clear and read the exact, because I kind of paraphrased it.
Definitely.
I'm going to read the
Read
exact.
it exactly.
It says, Barrow said, according to the witness, Barrow was the witness, that Smith started yelling for the crowd to move, and the witness Barrow said, y'all better move, I got bond money and I'm gonna catch a body tonight. And that was according to an arrest affidavit. A bouncer and other witnesses then saw Barrow reach into his pocket, pull out a gun, and shoot into the crowd.
Listen, I had cases like this as a prosecutor. What you're gonna do is do everything you can to eliminate any possibility that this eyewitness is confused. So you're going to challenge him. You can say, how far were you standing? Could you stand here and show me where you saw him positioned? And you'll be able to show, 5-10 feet away. And how was the lighting? And how long did you see him? Is it possible that you saw somebody else? No, absolutely not. Like, you have to deal with all these issues straight up and make it as airtight as possible, because then the cross-examination begins. That's when all of a sudden reasonable doubt will start to be created. But you've got to make an airtight case before you turn it over to the defense.
Let's talk about something, and I think you know a little bit about this too. So police reports indicate that Smith, one of the defendants in the case, told a female friend, maybe it was his girlfriend, whatever girl he hooked up with, that he effed up and that he did it when he was referencing the shooting, and he told the friend he was beefing with someone inside the club and got kicked out, and that he was not trying to shoot at anyone. Would something like this, would she be able to testify to this in front of the jurors?
100%. And right away, as you say that, the compassionate side of me, assuming this is really true, and he said it to her, kind of came out and went, oh, poor darling. Because those defense attorneys cannot live with the fact that that statement really was made. That would put their client in prison for the rest of his natural life. So who becomes the object of their scorn? That woman. And they're going to say that she has some beef. There's going to be some reason why she allegedly made that statement other than the fact that it really was said, and she's going to be ripped a new one, as we call it in the business.
And I mean, so basically it will come down to her credibility. And again, I imagine we haven't gotten into the bulk of really any of these prosecution witnesses, but I can only imagine that probably some of them are going to have credibility issues, and that could help the defense and hurt the prosecution here.
Everyone does. You know, as a defense lawyer, I look at everyone and I say, everyone has credibility issues, either because they have baggage or they have a record dating back to the disco crisis, or they're human, Rachel. Human beings make mistakes. We see things and we believe something, but we're not always accurate. How many times did I demand that that waiter bring me water until I finally say, look, we're parched over here. I've asked you 5 times, can we get some water? And he says, I'm not your waiter.
Wait, Mark. Okay, I breaking development here. So our trial producer, Kathy Russan, she just compared the state's witness list to the female friend that I just described you what she told police in a police affidavit, and she says that this woman is not on the state's witness list. What does that tell you?
Wow. It means that the prosecutors won't mention it. The only time it's going to be mentioned is on your show here. That's kind of cool. But for whatever reason, that means it will not come up in trial. The defense will stay away from it because it'll blow up in their face. They don't want any mention of that. So if there's no one listed who can say that, that statement doesn't exist as far as this trial.
But it makes you wonder. It makes you wonder if in your mind, like you were saying, you know, this would be great stuff for the prosecution. Right. There must be something wrong here if the state didn't want to bring her, and I'd love to have one of the prosecutors on to tell us maybe after the trial.
I'll tell you what happened.
Yeah, what happened?
Here are the options. Here we go. You ready? Okay. Number one, let's say she said that. Okay? And that would mean if she didn't say it, that law enforcement simply manufactured it and wrote it down. Odds are that's probably not what happened, okay? Although if I'm defending the case, I say that's exactly what happened. Okay, so let's say that she really said it, and law enforcement wrote it down. So many people get witness remorse. Later on, they say, holy cow, I mean, I didn't mean to get you in trouble. There's pressure from the community. They don't want to be involved. They don't want to be the reason why someone goes to prison. Their life is threatened, whatever it is. And so the witness backpedals. I never said that. You put me on the stand and say, no, he heard me wrong. I never said that. And then prosecutors say, and or she has so much baggage that it's not worth it. The defense will have a field day with her. So prosecutors say, we're not going to call her.
Well, here's something really interesting too, Mark. You know, we were asked specifically, because we're streaming this trial, not to show about 15 of the witnesses. And you know how Florida is. They're very, very open in being the Sunshine State with their laws too, allowing the public to view what's going on in court. And basically, you know, a judge would have to allow us to show the witnesses, but we were asked not to show by the prosecution about 15 witnesses. And that's because of fears that apparently some of these witnesses had about retaliation.
Sure.
So that leads me to wonder if that perhaps played into anything with why the state didn't want to call this particular witness up. If there's such a fear in the community of what could happen if your face is shown, you know, as retaliation or something like that.
Absolutely. I mean, us in the business, we deal with that. First of all, cases for the defense get better with age like wine. So let's start there. Every case for the defense gets better with age like wine. So in Florida, where we have liberal discovery rules, 3.220, you not only get witness lists, but you can take everyone's deposition. And people don't show up, and you take your time. And so then the case now is a couple of years old. People, their memories fade. They don't want to be involved. They get threatened. That happens. That's part of every single case. That's exactly what's going on, Rachel.
Is it unusual I know you've done a lot of high profile cases in your time, and a lot of times, they're being streamed, there's a lot of video cameras there. Will a judge ever, make exceptions just kind of on the media perspective? I'm just curious to hear from your perspective in not allowing cameras in the court. In other words, are they very much First Amendment friendly, allowing media there at all times? Because we were actually even shocked in a lot of the trials we stream in Florida, how lax the judges are even about exposing the names of jurors. A lot of times they just say them out loud in court when they know there's a live stream going on, which is shocking to us.
We're used to it.
Yeah.
It would surprise me if there's a judge in Florida who says you can't be in my courtroom, and I would encourage you, the media, to challenge it at every turn. We have a right to see those things. I'm not going to mention which judges, but a lot of these judges, they want their time in the sun. They like their ego's not their amigo. They like to be on camera. I've actually had some judges, and I will not name them, call me sidebar and say, you got an agent I can call? I'm tired of this gig. I want to get a judge show. So I'm not saying this judge. I don't know anything about this judge. I'm just saying, number one, the law allows for liberal views of what goes on in their courtrooms. And number two, a lot of them enjoy it. They pretend they don't, but they love it. They go home and their wife said, oh, you look great on TV.
Well, it's funny because I'm with you. I'm very much pro First Amendment, pro media access to trials. But I got to say that is pretty hilarious that a judge would pull you to the side knowing that you're on TV a lot, Mark, and actually ask you for an agent's number in the middle of a trial.
More than one.
Really? Okay. Wow.
Yes, it's bizarre.
Yeah.
Sometimes right after rulings, trust me, it's bizarre.
Well, listen, you let me know, those TV friendly judges, because maybe we could build a whole show here at Law and Crime around them. If they say some crazy things in court, you just never know. So let's, if you don't mind sticking around for a few more minutes, Mark, I want to play a little more testimony. We were going through Detective David Rodriguez's testimony. Let's play a little bit more of his testimony. I'll bring Mark back in. And perhaps if any of our viewers that are chatting with us in the chat room have any questions for Mark, send them our way. Of course, he's not able to watch every single minute of the trial, but he knows his stuff, so he could definitely tackle some of these questions. All right, let's listen to some of that sound, and we'll bring Mark back.
Hands, did you actually see any weapons?
No, sir.
And can you guesstimate how many people were coming towards you?
Approximately 50, 60. They're coming from the alleyway and the back of the club from two different directions.
Okay. They weren't coming from the front door of the club where the shooting
The alleyway is from the front door area. So you're going to come from the front door to the alleyway that splits Murphy's Oyster Bar and the entertainment establishment to where I am, and then the back door, and they kind of come at me at a V shape.
And the gentleman that Ms. Hawthorne talked about with the white lettering, was that a security person?
No, sir.
No?
Not that I know of.
Thank you, sir.
Yes, sir. Thank you.
And what is your current job title and duties?
I'm a District 2 property crimes detective, so I investigate auto burglaries, car thefts, arsons, stuff that's related to property crimes.
How long have you been a property crimes detective?
Since July.
Of this year?
Yes, ma'am.
Okay. So you had a different position in September of 2015, correct?
Yes, ma'am.
What were you doing then?
I was a patrol officer
Okay. And how long were you a patrol officer with OPD?
for about 2.5 years, give or take.
Any other positions with the Ocala Police Department?
Yes, ma'am.
What else have you done with them?
I've been a detective in the Criminal Intelligence Unit for a little over a year, and I've been assigned to some various violent crimes task force.
So at Were you on duty on September 13th, the early morning hours of September 13th, 2015?
Yes, ma'am.
In your patrol capacity?
Yes, ma'am.
Where were you around 1:30 that morning?
Before the call came out, I was downtown on the square right over here. The bars were about to let out, so that's typically where we would kind of congregate and wait for the bar crowd to disperse.
Were you by yourself in your own patrol vehicle?
There were several other officers downtown, but I was by myself in my patrol car, yes, ma'am.
How many other units were downtown on the square along with you?
I don't know an exact number, but there was a couple. 2 or 3 maybe, I'm not quite sure.
As you mentioned previously, at some point in time, a call comes out over the radio, correct?
Yes, ma'am.
And had the bars let out in the square at this point in time?
I don't believe so. I don't recall, but I believe it was about just after 1 or just before 1. And typically the bars wouldn't let out until about 1:30, 1:45. So not quite.
At the point in time that the call came out, what was the nature of the dispatch?
An officer got over the radio and said that there were shots fired at Cloud 9.
Okay, and what did you do in response to hearing that?
I ran to my patrol car, got in my car, turned my lights and sirens on, and drove as fast and safely as I could down to Cloud 9.
Okay, and where did you park your vehicle when you arrived at the club?
So when I pulled up, obviously there was a lot of traffic in front of Cloud 9, so I drove around the traffic and pulled I was still in the outside lane of South Pine, but I positioned my patrol car to point right kind of at the front door and entrance to the nightclub.
May the witness step down off the stand?
Yes, ma'am.
Yes, ma'am.
Sure.
Showing the jury what's been admitted as States 1, can you indicate the direction that you approached in your vehicle, the club?
So I would be heading south, so I'd be driving this direction, so this way.
Okay. And can you indicate on this diagram where you recall parking your vehicle?
It would have been right around here, approximately.
Did you park on the road? Did you park up on the sidewalk? Can you describe how you left it?
It would have been in the roadway. I don't know if I pulled up partially onto the sidewalk, but I was in the outside lane, kind of pointed right at the front door. So right.
What direction was the front of your vehicle on this diagram? Like, where was it pointing?
It would be kind of like this angle. So kind of, I'm not sure if that's directly south, but if this was directly south, it would be kind of like a southwest direction.
Towards the front of the club?
Yes, ma'am.
Yes. What'd you do after you parked?
I grabbed one of my equipment bags, and got out of my car and ran up into the crowd.
When you say equipment bags, what are you talking about?
They gave us, the police department, like a quick response bag. It kind of carries a various of items, and it's up to us kind of how we want to configure the bag. We can carry extra ammo, bandages, CPR mask, et cetera, stuff like that. Just kind of like a go bag, if you will. It just, you grab that and you're going to have essentials to deal with dangerous situations.
Okay. Can you describe to the jury what you see when you're getting out of your vehicle?
In layman's terms, absolute chaos. I got out of the car. There were multiple people in the parking lot by the road coming out of the nightclub. People were screaming, people were yelling. There were cars parked out in front in different directions. People were running in different directions. It was chaotic.
Did you see people that appeared to be injured to you?
As I ran up into the crowd, yes, ma'am.
Okay. One in particular?
Yes, ma'am.
And where was that person?
Miss Robinson was laying outside the nightclub on the ground, kind of next to the sidewalk as it ran in front of the club, like on the asphalt, but right next to the sidewalk.
How close was she to your vehicle where you parked it?
Approximately maybe 20 to 30 feet, give or take.
When you see her, what do you do?
So she was crowded. There was a lot of people standing over her, yelling and screaming. So as I ran up, and she was the first victim that I came across. And as I ran up, there were other officers responding, but I was going to assist her. I started to give loud commands for people to back away as I put some gloves on to assess the situation.
Okay. What did you do when you got to Miss Robinson?
After I was able to kind of clear her from other people, I got down and I started to kind of assess her injuries.
Okay. And what did you do to assess her injuries?
I immediately noticed that she had, there was a lot of blood on the ground. There was a lot of blood coming from her mouth and her head area. I assessed to see if she had a pulse. I did find a pulse. And because of all of the blood that was coming out of her mouth, I rolled her into a recovery position, which is on her side, to kind of help drain that as I continued to assess.
Okay. What did you notice next after you moved her to her on her side?
So I was trying to find out where all the blood was coming from, and I found one gunshot wound to the side of her head.
And what did you do after seeing the apparent gunshot wound?
There were other officers that were there at this point. They came quickly after I was there. I notified the other officers that she had a gunshot wound to the head and that I needed EMS now.
Did you attempt to perform any life-saving measures?
Yes, ma'am, I did.
What did you do?
So while I was assessing her, I noticed that her pulse went away. So I announced that I was going to do CPR. I rolled her back over onto her back, and I started to do chest compressions.
Were you asking for any additional equipment to help you do CPR?
Yes, ma'am. My CPR mask was not in this bag. It was in a different bag in my car. So I asked, it was Lieutenant Bianco, to go to my car and to get my backpack out of the car and bring it to me.
Okay. Did that happen?
Yes, ma'am.
Who all assisted you with performing CPR on Miss Robinson?
So Lieutenant Bianco brought me the bag. I handed the CPR mask to Sergeant Vizzini, who was standing over me, or behind me, kind of doing some crowd control. He started to do respirations, providing air to Miss Robinson as I was doing chest compressions. Something happened. I don't know. I don't know if the mouthpiece off of the mask fell off, but I guess it was contaminated by some blood. So I continued to do chest compressions. And then another female, I don't know who she was, showed up. I guess said she was a nurse, and she started to do air respiratory while I continued to do compressions.
Eventually, did medics arrive?
Yes, ma'am, they did.
Did they come to where you were with Miss Robinson?
Yes, ma'am, they did.
What happened at that point?
Well, before they arrived, I got tired, and Lieutenant Bianco switched out with me to do chest compressions. And then so I kind of stood up. I walked into the roadway to try to direct EMS. And so when they came in, they immediately started to render aid to Miss Robinson.
Eventually, did someone pronounce her deceased at the scene?
Yes, ma'am.
And what happened after that point?
So one of the medics or fire department personnel, they pronounced her deceased. They got up. I was trying to get the information from them, but it was so chaotic. He's like, you're going to have to get it later. And someone told me to grab a sheet and place the sheet over Miss Robinson.
Were you wearing a body camera that night?
Yes, ma'am, I was.
And did you activate it at some particular point?
Yes, ma'am, I did.
Do you recall when you activated it?
It was like right after it was very easy, just swipe them down and they turn on. That was the old model we had. And so it was just a habit. Anytime I got into a car or my patrol car and was running in emergency mode, lights and sirens, it was just immediate. So it was shortly after getting into the car downtown.
Okay. Did you also have an in-car camera that early morning?
Yes, ma'am.
And where is that mounted in your vehicle?
Right in the dash, somewhere along behind or beside the rearview mirror. So it's right there. It captures everything in front of the car.
How is that activated?
The cars are designed that as soon as you turn the lights on, it automatically turns on, and there's some type of back feed where it's constantly recording. So when you turn it on, it saves like the last so many seconds, so it catches sometime before you turn it on, and then when it reaches that point, it turns on the audio as well.
So when you say lights, you're talking about the emergency lights on your patrol vehicle?
Yes, ma'am.
And was that activated based on how you came to the scene that early morning?
Yes, ma'am.
And welcome back, everybody, to the Law and Crime Network. I'm your host this afternoon, Rachel Stockman, and you're just listening to some replay testimony from the Cloud 9 murder trial, a murder trial that we've been following here on the Law and Crime Network, and we've been streaming gavel to gavel for you. It's about 12:42 Eastern Time and in Florida, where this trial's taking place. And testimony is set to begin in just about 15 minutes or so. We have on the line our guest this afternoon, criminal defense attorney Mark Eiglarsh. And he's been giving us some interesting insight, especially when it comes to having dual juries. So very interesting information on that. As I mentioned before we went to that clip, we did get some viewer questions in to folks that are watching this online and following this on our chat rooms. One person wants to know, and I think you'll have an interesting take on this because you have been involved in some of these high-profile trials. Can you tell me if you think the camera affects the way the judge handles themselves during a trial? What do you think?
Great question. First, I can't answer whether it's affecting this particular judge because I don't know this judge and I don't know how he's acting now in comparison to how he normally acts. If we're asking the question in general, it can definitely impact on a trial. I don't particularly love cameras because if a judge is going to make a ruling and he can either go liberal or conservative, likely he's going to go conservative, especially when the world is watching and immediately people are going to say bad things about the judge and you know, it might affect his reelection. So I think cameras can adversely affect the case, and I think worse for the defense.
That's interesting. So you think they'll err on the side of the prosecution when cameras are involved, or just a conservative, less risky decision in terms of letting evidence or witnesses testify?
Well, both, and I think that generally favors the prosecution. I think that if they're going to throw something out or they're going to do something that favors the defendant, if the world is watching and they don't particularly care for the defendant, then yeah, that could adversely affect their opinion about the judge.
But overall, you still are in agreement the cameras are good and transparency is good in the courtroom.
I love them. I like seeing what goes on. We all have an interest. Yeah, why not? Except I still, to this day, have resentment over how Judge Ito presided over the O.J. Simpson case. I think he was grossly affected by the cameras, and you know, and I'm still troubled by that to this day.
And that's, of course, the prime example of when this all started and people being drawn to cameras in court and the boom of court TV, and now what has now migrated into Law&Crime.com and us streaming trials here on the network. So I want to turn really briefly, before I let you go, Mark, to the trial that we're covering, and that's the Cloud9 murder trial, where a young woman, 19 years old, Benitria Robinson, was killed. Several others were injured in this case, all involving a nightclub ruckus that spilled outside and ended up with, I believe it was 21 gunshots, according to experts. We had a firearms expert on the stand this morning confirming that she believed that there were 3 firearms involved in this. We just heard some testimony from one of the detectives that responded to the scene, and he talked about the chaos and how people were just running everywhere, as you can imagine, hearing gunshots in a crowded nightclub. How could that play to the how could that play to the defense in terms of trying to understand what happened?
We love that word, chaos. Chaos almost sounds, if you say it slow enough, it sounds like reasonable doubt. Chaos means that nobody can be accurate in what they're saying. They might be believable, they might look believable, but accuracy is a different thing. So I would tell jurors, and I have, and I've won many cases by saying the following to jurors. Hopefully you don't believe this witness, but in the worst case scenario, let's say you do. And when that witness pointed over at my client, let's say you're inclined to believe that witness. We all know that believability and accuracy are 2 different things. What scientific evidence corroborates, supports what that person is saying? The absence of any scientific evidence, in this case, because of the chaos, is reasonable doubt.
And again, you know, another factor in this case, too, is a nightclub. You have alcohol playing into this, too, and that can create fuzzy minds and hazy memories of what exactly happened.
Yes, and maybe they're token on the devil's grass as well, and some other substances, and just even if they're stone cold sober, which no one will ever know because no tests were done on these witnesses when they observed what they claim they did. Pandemonium, it's not that bright outside of any nightclub that I'm aware of, so the lighting is compromised even if they say it was adequate. Chaos can help create reasonable doubt, especially in this circumstance.
And Mark, before I cut you loose, because I know you're a busy attorney and have lots to do, I got one question. In Florida, a lot of the victims, 2 of them I believe, were under the age of 21. In Florida, can you get into a nightclub if you're under 21? Do you know about the rules there?
There are clubs that allow certain people in at a younger age. I'm not clear on whether this club had the authority to do so. That would lead to some potential civil responsibility, maybe down the road if there's a civil suit. It shouldn't and won't come up, I believe, in the criminal case.
And that's kind of what I was hinting to, that perhaps, you know, there may be a civil case in this if it turns out that these 2 victims were able to get into the club underage. Again, I know, like you said, some clubs do allow under 21. If you don't drink, you get stamped or whatever, and you can't get alcohol. So we'll have to kind of dig in a little bit more into that. Mark, I want to thank you so much for joining us here on the Law&Crime Network. We certainly hope you get back, and I hope you have a wonderful day. Thanks again.
My pleasure. Thanks for having me, Rachel. I appreciate it.